Could I start sharing the screen?
Yeah, just a moment, I'll quickly introduce you and then you can start.
No.
Good afternoon, everyone. Welcome to our second session of the Only One Theme series. So this is an awareness talk series on innovation management, technology innovation management. And this is the second talk in this series. So our today's speaker is Latha Nair, and she'll be talking on only copyrights. Briefly introducing Latha. Latha chairs the trademark, copyright, and geographical indications practice at K&S Partners. She advises clients on all aspects of the prosecution and enforcement of trademarks, domain names, copyrights, and geographical indications. Latha also handles transactional and advisory work relating to trademarks and copyrights, and regularly advises production and media houses on social media network companies on copyright issues. A niche area of Latha's practice focuses on the protection of geographical indications. She has been assisting the Government of India in the protection of certain well-known Indian geographical indications, such as Basmati rice and Darjeeling tea, both in India and overseas. She also actively represents the interests of certain foreign geographical indications, such as champagne, Scotch whisky, Irish whisky, some cheese varieties, to name a few in India. Latha is a regular speaker at various national and international forums on issues relating to protection and enforcement of trademarks and geographical indications. She is currently serving as a member of the Publications Committee of the International Trademark Association for the year 2022-23 as a term. So with this brief introduction about Latha, welcome Latha to the session, and over to you. Shall I request you to share your screen and begin? Latha, are you able to share?
Yes, we can't hear you.
You can't hear me?
I'm sorry. I think
She has not unmuted.
Yeah, I'm sorry. I muted. I just want to thank Venture Center for this invitation here this afternoon. I'm just going to share my screen in a minute. I am not very familiar with the... Okay, can you see my screen?
Yeah, we can see your screen, Latha.
Okay, is that better?
Yeah, we can see it.
Okay, all right. Okay, so I have 45 minutes to speak, I understand. There is a bunch of topics that I want to cover on copyrights that you can see on the screen. I'm going to go over it very quickly because it's just 45 minutes and then 15 minutes for question answer session. So today I'm going to speak about Copyright Act. I don't need to say that this is the act that is governing copyright law in India today. The last amendment to this act was in 2021 when the IPAB was abolished. It was more of a procedural amendment than a substantive amendment, and I'm not going to go into it. When you talk about what is protected under copyrights, you may have gone through other sessions on other kind of IP rights. Under copyrights, what is protected are original literary, dramatic, musical and artistic works. And when I say original, it's the original expression of these kind of works. So for instance, you and I may have an idea about one thing, let's say a sunset, and you make a painting and I also make a painting. Both of us, although we worked on the same idea, the expression of our ideas are different. So we get copyright in our respective works. So that's the same about any literary, dramatic, musical and artistic works. Then the Copyright Act also protects the cinematograph films and sound recordings. These are called mechanical rights because these are created through mechanical means. But these are also protected under the Act. So now looking at the works that are protected under the Copyright Act, let's say literary work, what are these? Anything that is written like a novel or a brochure of a company, or your website. Your website has a lot of stuff on it which are written as to what you do, etc. That's copyright protectable. Computer programs are also copyrightable, basically software works. When you talk about dramatic works, these are choreographic works or screenplays or storyboards, etc., where you kind of put in writing what the scenes of acting are. As far as musical works are concerned, these are the musical compositions and the notations that a musician writes down. All these will have to be fixed on a medium, or rather, written down somewhere. When you talk about artistic works, what would come under that would be paintings, sculptures, photographs, works of architecture, etc. Cinematograph films are obviously films, and even a film that you shoot on your own camera is a film. Anything that is audiovisual is a cinematograph film and is protectable under the Act as cinematograph film. And sound recordings similarly are recorded audio of songs or background music, etc. Now let's move to the next slide. So what are the requirements of protection? Section 13 of the Copyright Act deals with it. If a work is published outside India by an author on the date of, just give me a second, I think one of the, can you see my slides?
Yeah, we can see.
Yes.
You can see it, okay. All right. So is it okay if I go in this mode? Is that better?
Is full screen a problem?
Because I'm having a bar on top, which is kind of blocking my view.
Oh, okay.
Ma'am, actually in full screen, we are not able to see the spellings or the write-up.
Okay, all right.
Hmm.
And, I'm getting notifications in between saying that somebody is waiting, and it's a little bit
Yeah, so you'll just have to ignore those notifications because you're the co-host. We are admitting people at our end.
Okay, all right.
So, now is that bar visible still on your screen?
I've sort of pushed it down. So, okay, I'll go with this. No problems.
Okay.
So the requirements for protection are the work should be definitely published in India. Or if the work is published outside India, the author on the date of publication should be an Indian citizen. Or if the work is first published outside India and the author was dead at the time of publication, but he was an Indian citizen at the time of their death. Or if it is an unpublished work, the author on the date of making of the work must be a citizen of or domiciled in India. If it is a work of architecture, it must be located in India. And of course, under the International Copyright Order 1999, India is member of the Berne Convention and the Universal Copyright Convention. So works made in those member countries, members of those countries would be protected as if those were first published in India. Of course, the work must be original. And while the expression original is not defined under the Act, there have been case laws. So for a long time, Indian courts followed sweat of the brow principle, which means that, the effort that you put into making the work. And this originated in the University London Press versus University Tutorial Press case. However, in 2008, the Supreme Court of India came up with issued a judgment in Eastern Book Company versus D.B. Modan. So what happened here was Eastern Book Company, as many of you know, is the company that is publishes the Supreme Court cases So Supreme Court cases, they take the judgments from the courts and they add to it by, putting a head note, by making cross references, etc. And one party copied this. And when Eastern Book Company sued this party, DB Modak, before the Supreme Court of India, his argument was that judgments are, not copyrightable. But then the court noted that there was a lot of effort that Eastern Book Company had put into making, kind of improvising that copy and adding certain value to it. So the court observed that the work that comes into being, it should be original in the sense that by virtue of selection or coordination or arrangement of pre-existing data contained in the work, it's a different work in character that is produced, and which was the case here. So what the court felt was that you can't apply the rule of modicum of creativity. So you need to kind of come somewhere in between sweat of the brow and modicum of creativity, which is, the sufficient amount of skill that is used in that work to make it look like a work that is different from the original. So this was the test that was applied here, and that is a test that is used for originality today. So this is another very important aspect in copyright law, the idea expression dichotomy. As you know, there is no copyright that exists in an idea. Everybody has ideas. It is the expression of that idea that you get a copyright in. And this again is a very famous case of Arjian versus Deluxe Films. So here the plaintiff had produced a play, written a play, and it was produced. It was played a couple of times very successfully. And a film producer came to the plaintiff and asked rights to make that play into a movie. And the plaintiff agreed. However, the producer never came back. But after a few months, the plaintiff realized that there is a film being made. And when he questioned the producer said, no, it's not similar to your play. However, when the play, the movie New Delhi was released, it was a copy of the work that the play of the plaintiff. So here the court applied several tests, and it is still today followed by the courts in India. So one of the things that the court said is protection is confined to the expression of an idea. And it is the original expression of thought or information in a concrete form that is the protectable subject matter under the Act, and not merely an original thought or information per se. So the next topic that I would like to cover is whether registration is mandatory. So if you go to the Copyright Office's website and look at the FAQ section, this question is posed there, and the answer says that copyright you get by virtue of creation of the work, and you don't need to get a certificate. But certificate of registration of copyright and the entries made with the Copyright Office serve as a prima facie evidence before a court of law if there is an ownership. So when clients come to us asking whether we should register copyright, we usually tell them that unless it's a software that has a threat of piracy, we tell them not to register it. The reason being that when you want to file a criminal case for software piracy, cops usually ask for a registration certificate. And if it is not provided, then you can't really explain to cops in rural India that you get copyright by virtue of creation. So you need to show a proof. So it's practical to get that. And also under Section 45, the language used is that a person, the owner of a work, may make an application in the prescribed form. So it's not that it's mandatory. So there have been several conflicting judicial opinions on this particular aspect, whether registration is mandatory. A lot of courts that I have listed on the screen have held that it is not mandatory, but some of the high courts, including the Bombay High Court, have held that it is mandatory. However, in 2021, there was a very important case, Sanjay Soya versus Narayani Trading Company. Here, the court looked at various things and held that it is not mandatory and remedies for infringement, whether it's criminal or civil, are available even without registration. And the court actually found that one of its own earlier judgments in the matter, Dheeraj Dharamdas versus Sonal Info Systems, it was contrary and was without due regard to the law. The reasoning given by the court for this is that there is no provision in the Copyright Act that suggests that registration is mandatory. Section 45 we just saw, even that says that you may apply for it. Also, legislative history, when it was dug up by the court, there was one draft of the Copyright Act which said that suit for an infringement could not be initiated without registration. However, when that draft was presented in the final form, this provision was deleted, which shows the intention of the legislature. Also, if you look at Berne Convention, of which India is a signatory, it mandates equal protection to works of other member countries without any formality. So registration really is not mandatory. And now this is the decision that, the latest decision that is on this point. And it is backed up by the provisions of the Act. Now let's look at who can be the owner of a work. So if you make any of these, write a novel or write a play, you are the author of the work. Or if you're a musician and you make the graphical notations, you're the author. If you paint or take a photograph, you are the author. If you are the producer of a film or a sound recording, then you are the author of that. And author is the owner under the Act. But if you are causing literary, dramatic, musical, or artistic work, which is computer generated, then the person who's causing that work to be created is the author of the work. However, there are certain exceptions to this rule under Section 70. These are given as provisos. So the first of these rules is that works made in the course of employment. In the Act, it is given as employment in the context of a newspaper. So if you are a journalist working with a newspaper and you write articles for the newspaper, or if you're a freelancer with the newspaper for that matter, whatever you publish in that newspaper, the newspaper will be the author and owner of that particular work as a collective work. But if you are a commissioned author, the newspaper is commissioning you. While you publish that as part of the newspaper, the newspaper will be the owner of that copyright. But tomorrow, after your retirement, you want to compile all the work that you published in that particular newspaper and publish a book. The newspaper can't question you because these are your works that you published as part of the newspaper as a collective work. So you can do that. Now, government works are owned by the government. Government works would be any kind of literature published by the government, or even judgments of courts, etc. Same with public undertakings and international organizations. So why is copyright protected? It's protected because there is, you can derive economic benefits out of owning copyright. If you write a novel, I mean, look at somebody like J.K. Rowling. She was a very poor person. She wrote that novel and she became a billionaire. So copyright is supposed to give you certain economic rights. And what are those rights? So in respect of literary, dramatic, and musical works, there are various rights that are given to the owner of copyright. One is to reproduce in any material form. Two is to issue copies of the work. Then you can perform in public or communicate to the public. For instance, if you write a poem, you can go and read it out in the public. It's your right unless you license it to someone. To make a sound recording or a cinematograph film, or make any adaptation and translation of that work. If I write a book in English, I have the right to translate it into any language, including foreign languages. And I can even adapt it into a movie. So all these things play out in the real world as, sometimes you hear that Chetan Bhagat's Red Chillies got the rights to make a movie based on Chetan Bhagat's literary work. So it is basically an adaptation. When you make you kind of make a screenplay out of that literary work, and then you make a movie out of it. Or it also can be construed as a right to make a cinematograph film of that particular novel. Coming to artistic works, there are separate rights given. Reproduce it in any material form, including depiction in 3 dimensions, to communicate to the public. The 3 dimensions or of a 2-dimensional work, or 2 dimensions of a 3-dimensional work. It's both ways. You can do that. To communicate it, to issue copies to the public, and to include it in any cinematograph film, to make any adaptation of the same, and to do in relation to an adaptation any of these. So I did mention computer programs in the earlier one. In addition to the rights which are there in the earlier slide for literary works, computer programs, you can also give it on commercial rental. Now, as far as cinematograph films are concerned, there are 4 economic rights granted. One is to make a copy of the film, including a photograph of any image forming part thereof. So in practical scenarios, how this pans out is, you go to a movie theater, you see posters of the movie. So these are photographs coming from the film, which are kept there for advertisement purposes. To sell or offer for sale any copy of the film, which they do on various platforms now, to give on commercial rental. For a long time in India, I think till the 1990s, there used to be these video parlors which were unauthorized, which was stopped through one judgment, because it was made clear in that judgment that commercial rental, to give a film on commercial rental, was the right of the author. You can't just start a video parlor without license. Then communicating the film to the public. For sound recordings, also there are somewhat similar rights to make any other recording embodying that, to offer for sale, communicate to the public, and then give on commercial rental or offer for sale. Now let's look a little deeper into the economic exploitation of the rights. Section 18 and 19 of the Copyright Act deal with it, coupled with Section 30. Now, Section 18 and 19 talk about assignment, and Section 30 talk about licensing. So when you talk about assignment, it is equivalent to sale of that right. But when you talk about licensing, it's the ownership is still with the owner of the copyright, and you're given certain rights. And in both cases, unlike a trademark assignment where you have to assign the whole mark unconditionally, in the case of copyright, you saw that each of those works have several economic rights attached to it. For instance, if I have written a novel, I can decide to assign only the right to make a cinematograph film to somebody. The rest I can keep with myself. For instance, issuing copies to the public, or making audio books. All of those are something that I can retain to myself, or make an adaptation, etc. So what are the rules that govern assignment and licensing? And this is something, again, that has practical relevance to companies that deal with copyrighted works. So an assignment has to be always in writing, and it must be signed by the assigner, that is the owner, or the licensor if you're licensing it. What should it contain? It should contain the details of the work, the rights that are being assigned. Like in the case that I give, if I have 3 rights, I want to assign only one of the rights, the rest 2 I can keep with me. So the assignment agreement must state what right is being assigned. The duration and the territorial extent. So if you don't state the duration, the Act says that it would be presumed to be for 5 years. And if you don't state the territory, it would be presumed to be within India only. Also, the assignment agreement must specify the amount of royalty or any other consideration that you're going to pay in there. If the rights are not exercised within 1 year from the date thereof, then these would revert to the owner. And in case of works of joint authorship, consent of all authors are required for exploitation of any rights. Not one author can, a single author cannot, enter into an agreement. Now, let's look at the term of copyright. In the case of literary, dramatic, musical, and artistic work, it's life of author plus 60 years from the beginning of the calendar year next following the year in which the author dies. Since it is a mouthful, I've given an example here. Let's say Mahashweta Devi, the very famous author. She died in on 28 July 2016. Now, her works, she enjoyed copyright till that day. Plus, from January 1, 2017, for another 60 years, she will have copyright in that work. So similarly, cinematograph, films, and sound recordings, government works, works of public undertaking, etc. These are for 60 years, beginning of the calendar year next, following the year in which the work was first published. So let's say Brahmastra, the movie, it was released on September 9, 2022. So now the film will be within copyright from now. From right now, it is in copyright. And then the 60 years would be calculated from January 1, 2023 for another 60 years. The Copyright Act also gives a very interesting right called, it's there in the law in various countries, moral rights. So these are basically the right to claim authorship, the right to integrity of the work, right to restrain or claim damages for distortion, mutilation, etc. Then right to attribution. These rights cannot be assigned or waived. So I can give you a very interesting case law that was before the Delhi High Court some years ago. In Vigyan Bhavan, there was an artwork, a huge mural that was kept. And when Vigyan Bhavan was going to be renovated, the people in charge of that building took the mural and threw it, dumped it in one corner of somewhere. And the painter, the person who created that artwork, the artist, he sued Vigyan Bhavan and the Union of India before the Delhi High Court. And the court directed that his right to integrity be upheld and the painting be, taken away from wherever it was kept and restored to its original shape. So this is the right, the moral right, or called the author's special rights. Now, there's something called neighboring rights. These are basically the broadcast reproduction right, which are given to broadcasting organizations like TV channels, etc. This is for a period of 25 years. There is also something called performer's right in section 38. So performer is a person who's an actor, singer, musician, dancer, or a person delivering a lecture. Right now, I am being a performer here. So performers have a right to their performance. And performance in relation to performance rights means a visual or acoustic presentation made live by one or more performers. So if you look at these related or neighboring rights of the performers, what are the rights of the performers? The right to make a sound or visual recording of the performance, or the right to broadcast or communicate the performance to the public, except where the performance has already been broadcast. Moral rights of a performer are to be identified as the performer of the performance. This actually is included by the 2017 amendment to restrain or claim damages for any distortion, mutilation, etc. of the performance. The term is for 25 years from the beginning of the calendar year next following the year in which the performance is made. Now let's look at infringement of copyright. Section 51 deals with the infringement of the copyright. So what is a primary infringement? If somebody, without my permission, exercise any of the exclusive rights granted to me under Section 14, that becomes a primary infringement. Or if I have given a license to someone and that person has breached the terms of the license, then that is also a primary infringement. Then again, selling, letting for hire, offering for sale or hire, or distributing, exhibiting, or importing infringing copies of work. That is also, these are also primary infringement. Now, what is secondary infringement? Secondary infringement is you are allowing a platform, for profit. You're permitting it for profit to be used for unauthorized communication of a work to public. So that's secondary infringement of copyright. You don't directly commit it, but you cause it to be committed. Now, I talked about the Arjian case in the beginning to talk about the idea versus expression dichotomy. This case also has other, interesting aspects regarding how to figure out whether there was an infringement in a particular case. So here, the facts of the case I explained to you. So the court looked at this particular case and laid down several principles, some of which I have highlighted here. So one of the things that the court said is that when you're developing the same idea, similarities are bound to occur. But when in such a case, what should be looked at is whether the similarities are on a fundamental or substantial aspect of the mode of expression adopted in the copyright work, because what is protected is the originality in the expression. And when you look at it that way, if the defendant's work is a literal imitation of the copyrighted work, then it is a violation. Also, this again is a test that the courts apply even today for testing whether there has been violation. That is to see if the reader, the spectator, or the viewer, after having read or seen both the works, is clearly of the opinion and gets an unmistakable impression that the subsequent work is a copy of the original. So this is a test that is employed even today by courts. But the court said that if the theme is the same, but it is presented and treated differently, there cannot be any question of copyright violation. So apart from similarities appearing in the two works, there could also be material and broad similarities which can negate the intention to copy. And the coincidences appearing in the two works are clearly incidental. There cannot be infringement. No infringement of the copyright comes into existence. Since I have laid down all these, put down all these principles in the slides, and I think the institute is going to share with you. So I'm going to move into the next one due to paucity of time. What could be the remedies for infringement? So if you're filing a civil case, you can get injunction, damages, and accounts of profit. Under criminal remedies, you can be imprisonment for copyright infringement, and you could be liable for fine, which can go up to 50,000 rupees to 2 lakh rupees. So one of the longest sections of the Copyright Act is Section 52, and this is a very important section for copyright lawyers and for those who use copyrighted content. This section actually lists out what are what are the acts that do not amount to copyright infringement. So one of the main things is fair dealing. And what could be fair dealing? Fair dealing could be for private or personal use, including research, criticism or review, reporting of current events and current affairs, including the reporting of a lecture delivered in public. Apart from these main 3 points, the section also lists out about 2.5 pages. The section goes into it lists out the exceptions in the case of each of the works and each of the situations, whether it is educational purposes or for archival purposes, etc. And it also has exceptions meant for visually impaired people, etc. However, the question of fair dealing is something that has to be looked at from a factual perspective. For instance, recently a client came to me saying that their image is being used on a website by somebody. So when we sent a legal notice to this party who was using the image, the party came back and told us that it's not a copyright infringement, and they are an educational institution. So they said that for educational purposes, we can use it. But if you go back and look at the section that deals with educational purposes, it's very limited. It talks about using that work in the course of a lecture, and that way it is dealing with literary work. Here, the work in question was an image. So we went to the main section that is dealing with fair dealing. And this is in respect of any work. And the third bullet that you're seeing there, reporting of current events and criticism, second bullet that you're seeing there, the complete sentences, criticism or review of that work or of any other work. So the article which they were talking about was a technical subject, and they used our client's image just to put it there to increase the aesthetic and visual appearance of that particular article. So it was not a criticism of that work or criticism of any other work. So every time when you look at fair dealing, you have to really go by what the facts are. And if the facts indicate that it was something that was not in a commercial sense, or that is falling within the four square corners of the law, then that can be exempt. Also, one of the things that the courts employ is it's called a thumb rule. To apply to an event or an affair being newsworthy would be a time period of 24 hours. So this is something that is used when somebody takes the defense of reporting of current events. Then the third one is that I have put there is use of judgments by a tribunal, etc., unless the reproduction or publication is prohibited by the court. So in this case, the concept of de minimis was used by the court. There are actually a couple of other judgments also. So basically what this principle says is that if an infringement is very trivial, it amounts to de minimis use of copyrighted work, and cannot be, if that use is very minimal, then it cannot be a copyright infringement. And you need to look at factors like the size and type of harm caused, the cost of adjudication, the purpose of the violated legal obligation, the effect of the legal rights on third parties, and the intent of the wrongdoer. So one of the cases was where an advertisement was aired for educating consumers about MRP. So it actually shows a kirana shop. And in the kirana shop, when a person enters, the song Kajra is playing, and it is only for 10 seconds. Then it is a conversation between the shopkeeper and the consumer. And it's basically talking about what MRP is. So here the court felt that the plaintiff, who was the copyright owner in that movie, complaining that the copyright is violated there, that was a very small use of 10 seconds that cannot even cause harm to the plaintiff in that sense. And the purpose was to educate, and people wouldn't be watching that ad to listen to that song. They would be watching that ad to understand what ERP is. And the intent of the wrongdoer here, in this case, the one who made the ad, was mostly to educate the public. So I have another few minutes left. I understand that some of the persons in this group are startups, and before I conclude, I just want to give some tips for those who are startups in this group. So one thing that I have noticed with startups when we deal with them is that they think that protection of intellectual property means protecting only patents. So there are very few startups who take copyrights and trademarks seriously. So my first tip is, do not take copyrights and trademarks lightly. Because there is a lot of stuff that you create that are actually copyright protectable, be it your website, the brochures that you create, the artistic logos, etc., that you create. These are all protectable as copyright as well, in addition to protecting them as trademarks. So to give an example, a client recently came to me. It's an Italian client who is doing business in India. And very innocently, the Italian client gave the one of the distributors came and asked to give a copy of their brochure, and the client gave the brochure. And now the distributor actually copied that brochure word to word and started his own business using that brochure. Now the brochure just has information about my client's products. It doesn't have any copyright notice as to when the brochure was published. Now, if he has to go to court, how will he prove to the court that he created that work much before this distributor even produced that brochure? There is nothing in it, no year of publication, nothing. So it is very important to put a copyright notice on your website to protect the contents of the website, or the content of your brochure, or the content of any kind of literary work that you think is important. If you may sometimes have manuals, etc., which are meant for whatever purposes. If somebody violates those and you want to take action, copyright notice is important. And I've given the example of how to give a copyright notice there. If I am the author of a work that I created in 2022, I can put C in a circle, the year 2022, and my name, and it's as simple as that. So it shows that I created the work and it's proprietary to me. If you are an intermediary, you should know your rights and obligations. And when I say an intermediary, I mean someone who offers a platform for sale or a platform for music, etc. You are asked to take down an offending work. The moment you have knowledge and you don't do it, then you've been asked by way of a court order, you will have to take it down. If you have knowledge and you don't act on it, then your liability starts to kick in. So these are some of the tips that I want to give the startups here. There are more tips that I could give on trademarks, but this is a presentation on copyrights, and so I'm limiting it here. And I think that is the end of my presentation.
Thank you, Latha, for this wonderful presentation. Very difficult to summarize, I think, all the aspects that you have covered. So just picking up from your last slide, actually, there are several questions in the chat box already, but just wanted to check one thing about the tips that you gave to startups about copywriting their website. So I had a related question, actually. Like the website keeps on changing dynamically, a lot of things keep on adding. So how does it work?
Very good question. So I'm just going to put that on the chat box, how you can do that. My C in a circle is coming as bracket. And let's say that I created this website in 2018 and now I am in 2022. This is how I will put my copyright notice. So you'll say 2018 to 22 and then the name of the owner of copyright.
So when the next version comes, you just extend it to say 23,
yes,
24.
23. Yes, absolutely, absolutely.
Right. And similarly for their product brochures also, is it?
Yes. So product brochures, and also you can do that. You can say 2000 whenever you started creating it. But if it's a most recent edition, you would put the copyright for now. I'm talking about things that keep evolving and things that are archived in the website. You may have stuff going back. This is more for the virtual world. In the physical world, you can always put the correct information because it's a printed copy. That's not possible on the digital version.
Right. So a related question that Bhagyashree has is that can we copyright the tagline for our startup?
So there is no copyright for slogans because it's too short a thing to be copyrighted unless you kind of make an artwork of it. So there are ways to do it. One of the ways is to create an artwork along with it and then register it as an artistic work.
Okay, so artwork along with the tagline can be registered together.
Yeah, but then, the artwork should be substantial to get a copyright registration as an artistic work. So you'll get a copyright registration for the whole thing. But the tagline alone, you cannot copyright because it's too small to claim originality.
Okay. There's one question from Hardik Vora who says that is copyright registration certificate necessary when assigning or licensing the copyright?
Assigning or licensing the copyright. So it is not necessary so long as you can prove that you are the owner of the copyright. So I'll give you an example. I have written a novel and I have not registered the copyright for the novel with the Copyright Office. However, I have a copyright notice. Now you came to me, Hardeep, asking to assign the rights for making a cinematograph film. Now I enter into an assignment agreement with you and I give you the rights. Now that assignment agreement is actually your ownership title for that right to make a cinematograph film. So even without, and so tomorrow you want to assign that right to somebody else. You don't need to go and register it with the Copyright Office. You may if you wish, but it's not mandatory. And you can go to that third party who's asking you to assign that right with this assignment document and assign it further to that third party. So that's your title. Is that clear?
Yeah. Thanks. One more question is about, is there a royalty concept related to copyright or this is more related to the patent?
So copyright is also, you do get royalty. I mean, how do you think J.K. Rowling became a billionaire? So it's from the royalty from the book that she wrote. So for every copy sold, or right now it's like virtual, like every view or every subscription, you get a certain amount of royalty for that work. So royalty is basically the reward you get, the economic benefit you get from disseminating that work to the public. So, I mean, is that clear?
Yeah, got it. This is one question about this social media thing. Poetry on your own social media page. Can you protect it by copyright?
Yeah, you put a copyright notice on your poetry, and then you can protect it, like a copyright notice that I gave you. So, I mean, I have had one client who keeps writing poetry and putting it up on her Instagram pages. So, when I had to tell her to put a copyright notice on it to protect it from being copied. The moment you put the copyright notice, it shows that it is proprietary to you.
Yeah, so it's the same way, same thing for like there's an Insta page for the startup. There again, you can put a copyright notice.
Yes.
Right.
Yeah.
There's a question regarding published literature. Is the copyright belonging to the journal or the investigator who has published the article?
Content of a published article in a scientific journal of investigators. Who are the investigators here?
Investigator meaning she means who has written the paper.
Okay. So again, I think I covered it in the presentation. So when it comes to a journal or a newspaper, the publisher of that journal will have the copyright in that work so long as it forms a collection of that journal. But you will have a separate copyright if you take it out of that and publish it separately as your own. So it depends upon the context. And I'm talking about Indian law. If it's an Indian work, and if you are the author in that, you have a separate right to publish that work unless you have agreed otherwise with that publisher. The publisher says that you cannot publish it separately other than as part of this journal, then the entire copyright is with the scientific journal.
There's one more question. There are many cases when music directors copy music from a more popular international release. If copyright is applicable globally under the Berne Convention, why are music directors not held liable for copying the music?
Who said they are not held liable? I mean, it's just that they go scot-free because nobody gets to know and go after them. You do have to get rights. In fact, I don't know how many of you watched the movie Forrest Gump. Forrest Gump and the latest one, Lal Singh Chadda.
Lal Singh Chadda, yeah.
Yeah, so Lal Singh Chadda, Amir Khan got the rights for that movie from the producer of Forrest Gump. Anything that you copy, you will be chased. It's just that somebody doesn't know that someone in India has copied the music. If they're caught, they will be, held liable for it.
Sure. There's someone who's raised their hand. We are going to unmute the person. Yeah, Prajakta, you're unmuted.
She's muted again.
Yes. Ask to unmute. Prajakta, you can ask your question.
Hello.
There's an echo, Prajakta.
I had asked question related to published literature. So, for example, if there is a scale which is developed by some originator and it is published as a part of the article. So, in that case, that scale per se will be because the investigators have made it or formulated it would be the copyright of the author, or it because I have given a copyright transfer, so the new person who's using the scale has to take permission from the journal or the author.
Prajakta, I'm sorry, I'm not able to understand your question. What is the scale?
So I think, Prajakta, you're talking about the physiotherapy measurement scale, right? Prajakta, we are not able to hear you. I believe you're from the Sancheti College of Physiotherapy. So I think it's related to some measurement that physiotherapists do, and her question is related to that.
See, the rule is that if you are the one who wrote that article, you have a copyright over that article as the author. But the moment you sent it for publication to a publication, a journal like the one that you've referred in your question, that journal will have copyrights in that article as part of a collection, as a collective work. That doesn't mean that tomorrow you cannot publish this paper that you wrote separately somewhere, provided again that there is no agreement to the contrary with the journal. I don't know if I've made it clear.
Prajakta, is it okay? She's saying thank you. Yeah, next question I think is from Bhagyashree. Bhagyashree, we have unmuted you.
Thank you. Hello, ma'am. Very informative lecture. Ma'am, my question is regarding, as you said, you can say copyright and that date, like 2018 to 22, you have right in chat box. But for that, first we have to copyright our poetry or whatever we are adding on social media page. First, we have to copyright that, or how? Because anyone copied, and that time we have to means how we can get justice if it is done by other person.
So, so let's say that you have an Instagram page and you write poetry and you put it up on the Instagram page. If your poetry is appearing on the Instagram page with the copyright notice, the world is notified that you are the owner of copyright in that. And let's say that there are people who are copying it, then you have a right to actually raise it with that person and tell that person to stop using it because your copyright is being violated, and you've notified them using this particular feature, which is the copyright notice.
Okay. But first I have to register my anything like copyright site, and I have to register myself, or
No.
what should I do?
So that's what I said in the presentation. Copyright registration is not mandatory in India. There was a 2021 judgment that I referred to. You can go back and look at the slide, which I think the institute has. There is no need to register copyright. Unlike other IP rights which need to be registered, what happens with copyright is that the moment you create that work, you become the owner of copyright in that.
Okay, thank you.
So now you can unmute yourself to ask the next question.
Ma'am, I was unmuting to actually because Prajakta also was here and she was wanting to. So I have put on the talk on the laptop. So it would have been more clear for her to speak from here. That's why I was requesting.
All right. So there's no question you're saying.
Yes.
I think there's one question from Mary. Mary, do you want to unmute yourself?
She's breaking up.
Mary, are you speaking?
Hello, can you hear me?
Yeah, now we can hear you.
Yeah.
Go ahead.
So if you want to copyright a web page, you'll
Mary, you need to be a little loud. We are not able to hear you well.
Okay, when you want to copyright your web page,
Yeah.
when you want to copyright your web page,
Yeah.
so enough that you give the screenshots of the web page, or you have to give the source code, I mean, of the program that has been written to the page or whatever.
I see your
Such
question.
things are also.
Okay, so when I say web page, what I mean is that like if you go to our firm's website, canispartners.com, you see a lot of information out there. That is what I meant by the web page. Now the program associated with it is that the software that is hosting that website, right? Is that what you're asking? That is protectable separately.
Yes.
Yeah, that is protectable separately. That I think mostly, I'm not a technical person, but I'm guessing that one would use something like a Microsoft Office 365 or something which is a licensed software platform. For that, I think you are already using somebody's copyright to host it. That's a platform, that's a structure on which the web page works. I was talking more about the information, any web page you go, there would be an about us page, who we are, our people, our team, what we do, etc. So that information that you put up there, that is a copyrightable literary work. But coming to your question
So the
on
screenshots have to be given.
No, you don't have you don't have to do anything. See, there are two things here. I don't know if I made myself clear in the presentation. You have a choice to register your copyright, and you need not even register it actually, but you have a choice to register it if you want to. And if you want to register this web pages of a particular website with the Copyright Office, yes, you need to take a print of that entire web page by page. You need to take printouts or screenshots and go and file it with the Copyright Office as a literary work. That you can do, but you need not do that because the purpose of that copyright, showing that you are the owner of the copyright would be served by a copyright notice.
Okay. Yeah, thank you very much.
Sudhar, could you want to ask the next question? Latha, I hope you have a few minutes more.
Yeah. So can you comment something about the software copyright, like any judgments, or how is that working in Indian scenario? Is it I mean, software
So
protections.
Yeah. So the first case that I read when I, joined the firm that some 24 years ago was a copyright software case called Justlo Labs versus Whelan, I think. That is the only copyright, that is the first copyright case on software, I think. But in India, we don't really have any case that there may be, I'm not aware, at least I haven't heard of any, that deals with the issues on software, copywriting, etc. But mostly what has happened is that in India, the cases are relating to infringement of copyright and award of damages. And a lot of damages are awarded when copyright of companies like Microsoft and Adobe are violated. But if you have the opportunity to read that case, Justlo Labs, what they have said in there, I read it many years ago, but I'm trying to recollect from my memory and say, what they basically say is that even, the structure, so there it was a dental lab. This particular dentist created a software to deal with the patients who are coming daily into the, the dental lab. And someone copied it, or the person who created the software itself gave the idea to somebody and they copied it. So there was a copyright infringement suit. And what the court said is that it is not just so what they do is that they would basically compare the two source codes and see where it is copied. So here the court even went to the structure of the software and said that if it is not functional and if that structure is copied, even that would be a violation. My memory may not be right, but you can go back and read. I can type down the name of the case. I think it is JASLOW. If I get the correct case, I can send it to Venture Center and they can share it with them. I mean, there isn't any case that I am aware of in India where they discuss the issue of software copywriting. But now that you asked the question, I want to tell you that it's a very limited protection that you get for software as a literary work, because copyright actually protects the originality of expression. So what happens in copywriting a software is that you give that source code for protection. And when you have to compare, and what is being protected is just the way in which that is written. And I mean, if any of your coders, you know how source codes are written, there is nothing really literary about it. So it is just that arrangement of the language that is protected. So nothing beyond that. So it's a very, very limited protection that you can get by copywriting software. Yeah. So someone has asked, we only submitted a few pages. So how is the actual full code claimed in the IPO? So very good question. So the purpose of submitting that code, and now the rule is that you can submit the first 10 pages and the next last 10 pages. And if it is less than 20 pages, you have to submit all of it without redacting anything. So that's a new rule. So here, what happens is the purpose of asking you to submit that work is so that they have a record of it, because they are not going to scrutinize it. They are not technical people to sit and check if there is originality in it. Anyway, that is not a test at all. That is conducted by the Copyright Office. The purpose is to issue you a registration, and without that, you know, at least part of that work that is there, you can't determine whether there's an infringement. So somebody is violating your copyright, you need to actually get a technical expert to compare both the works and see if it is copied. So for that, some amount of that code should be there. It need not be the full code. So if, you know, the full code is filed, well and good, but mostly software owners are reluctant to do it because they feel that it could be, copied and violated.
Yeah. Thanks, Latha. I think we've taken all the questions in the chat box. In case there are any additional questions, I hope it's okay. We get back to you over email for any additional questions. So addressing the audience again, thank you for attending today's session. And also please do give us feedback for this session. As you know, we are going to have regular sessions on second and fourth Tuesdays on different topics, one topic at a time. And this is going to go till May 2023. So more critical the feedback, we will try to improve our sessions further on. So please do give us feedback for the link on the link which has been shared in the chat box. This link will remain open till today night, and we will close it by tomorrow morning and analyze the feedback. It will be shared with everyone and also with the speaker via a restricted website. We will also share Latha's presentation via restricted website along with the recording of this session, which will be sent to you over email. So thank you, Latha, and once again, formally thank you on behalf of Venture Center and our team for making time for this session.
Thank you so much for inviting me.
Thank you.
Thank you. Bye-bye.
Bye. Bye. See you.